So we have a quorum, so let's call this meeting to order. This is the panel on constitutional affairs. So let's invite the administration in as well. First item on the agenda, information papers issued since the last meeting. We issued a paper, and that's CB bracket 248/1213 bracket of 01, and that is concluding observations issued by the United Nations Committee on the Rights of the Child in respect of the combined third and fourth report of China, which includes the report of the Hong Kong SAR. Items for discussion at the next meeting. We have with us today Secretary for Constitution and Mainland Affairs, Mr. Raymond Tam, Deputy Secretary, Mr. Gordon Leung, and Principal Assistant Secretary, Mr. Freely Chang, and Chief Electoral Officer, Mr. Lee Pak Hong, and Deputy Chief Electoral Officer, Mr. Sham Nam Long. So, welcome to you all. Date of the next meeting. It will be held on the 18th of November, on a Monday at 2:30. The Secretary has proposed 2 items for discussion at that meeting. So over to you, Secretary. Thank you, Chairman. First of all, thank you all members for your effort. I hope that in the coming term, our meetings can be conducted smoothly. I have suggested 2 items for discussion at the next meeting. The first one is about some technical amendments to electoral laws. We hope that before the bill is tabled, we can consult members at this panel. Now, some amendments have to do with the present electoral arrangements. It is hoped that the administrative arrangements can be set out very clearly in the law, and we also like to improve some of the electoral procedures and to repeal certain outdated provisions. We're going to submit papers and brief members on the details of our proposal. The second item has to do with the submission of reports. The second report in relation to the Convention on the Rights of the Child of the United Nations Committee. On the 20th and 26th or 27th this year, the committee already held the relevant meetings, and Mr. Lau Kong-wah already led a deputation and attended the meeting. I understand that at the last meeting, some members have suggested discussing this item. So I'd like to report to members at the next meeting the deliberations of that meeting. And again, papers will be submitted. So these are the 2 items proposed. Now, in relation to the second report on the rights of the child of the UN Committee, the Secretariat has also invited deputations to write in. Ms. Emily Lau, some deputations are very keen to express their views on the committee's meeting, and they'd like to hear from the government as well. So please arrange for sufficient time for them to express their views. Well, Chairman, the Chief Executive has announced the setting up of a committee led by the 3 principal officials. I'd like to know when they are going to come to consult us, because some views have been expressed extensively in the community, and that they should fully get hold of the situation. I'd like to know, Chairman, when a meeting will be called for on this topic. I know that a press conference was called for, and I want to know when you're going to come to this panel. Secretary, please tell us when you're going to brief us on your work. Perhaps after this meeting, we will discuss with Chairman when would be an appropriate time. And as mentioned by the Chief Executive, consultation will be launched towards the end of this year. It's already end October, so after the meeting I will discuss with Chairman as soon as possible the best arrangements. I hope that the special meeting can be held. Apart from the Director Bureau, I hope that the CS and also the Secretary for Justice would also attend to tell us what work will be involved and what the consultation paper will contain. And I hope this can be done as soon as possible. Yes, so your view has been heard. Dr. Helena Wong. I hope when the administration comes to brief us on the proposal, please also tell us the progress on the formulation of a timetable for the 5-step mechanism so that members at this panel will also know what preparation to do. All right, Secretary? Anything to supplement? The Chief Secretary of Administration also stated that the 3 Principal Committee is deliberating internally the relevant matters, including the points raised by Ms. Emily Lau. Perhaps after the meeting I can discuss with Chairman the most appropriate arrangements. So, all right, these 2 items for the next meeting. So let's move on to the 3rd item. Mr. Charles Mok, I issued a letter to you, Chairman, in relation to the problem with personal data in the public domain. The Office of the Privacy Commissioner banned an app, and it caused repercussions among the general public as well as the IT sector. Perhaps we should be consulted on whether exemptions should be given to the disclosure of personal data in the public domain under some circumstances in the law. And there has been a response from the office as well. I'd like to include this on the agenda item so that a chance be given for them to explain to us. Who should do the explanation? Is it the Office of the Privacy Commissioner? Yes, as well as the administration. If something is missing from the previous consultation exercise, then in the next one, this element should be included. Most recently, in other places like Singapore, etc., as far as the personal data in the public domain is concerned, exemptions are granted, but not in Hong Kong. Well, I understand that in the CE's questions and answer session on the 16th of October, he gave you a very detailed reply. He said that in 2011, about the Personal Data Privacy Amendment Bill tabled in the Council in 2011, no element of exemption was included and no queries have ever been made in this regard. So there's been a very detailed reply, but I'd like to know more, Chairman. Please arrange for a discussion here. Any response from the Secretary? Chairman, what you said just now is correct. Last week, in a written question, we gave a detailed reply to Mr. Charles Mok's question. In 2009-2010, as far as the consultation, the review was concerned, the issue raised by him had been dealt with. Based on the written submissions received and based on the deliberations carried out in this Council on the last amendment bill, we didn't find it necessary to further deal with this issue. In relation to the use of personal data obtained in the public domain, the Privacy Commissioner's office issued a set of guidelines in August this year. And I understand that in 2013, on the 30th of August, the office also held a seminar with the sector to explain to them the application of the Personal Data Privacy Ordinance on the use of mobile applications. So in relation to the guidelines, very recently, less than 2 months ago, in fact, the Privacy Commissioner did explain to the sector by way of seminar. At this stage, we don't see the need to further review the law. Chairman, I don't want to start a debate here, but it is exactly when you read the news on Saturday's newspaper, 77% of our sector had views on the guidelines. They think that the guidelines are either too strict or they're outdated. And the PC commented that we are biased, so I don't think the issue is resolved. There is no urgency in this matter. We don't necessarily have to discuss it at the next meeting, but still we need to resolve this. Well, Secretary already explained just now that the bill had been passed not long ago. The law has just been implemented. They don't intend to follow up or to further amend the law at this moment, but we can, of course, discuss with the administration to come up with some arrangement. So, on to item 3 of the agenda, voter registration, statutory deadlines and offences related to voter registration. 2 papers have been circulated among members. One is CB-266/13/14/03. That's administration's paper, and also bracket 04, another paper, which is the background brief prepared by the LegCo Secretariat. Maybe I'll invite Mr. Tam, Secretary, to take us through the administration's paper before the floor is open for members to ask questions. Secretary, please. Thank you, Chairman. Well, this paper deals with the voter register, the VR. Since the last election, the REO and the administration enhanced the measures in conducting inspections and checks. We recall that during the last term of the SAR government and the council, a series of improvement measures had been implemented, and those measures have been explained to members. And for issues or proposals which are more controversial, we conducted a consultation, and the consultation report has been submitted to the panel on constitutional affairs for members' reference. During the last term, we already notified members that in relation to 2 suggestions, we are going to state our positions. One is in relation to the paper, whether the timetable should be changed, especially in relation to public inspection of the VR, and whether the deadline for applying for change and lodging claims and objections, etc. Apart from that, the panel also asked whether there is any alternative timetable which can be fine-tuned to meet the needs of the VR cycle. Now, in paragraph 10, we summarized the proposals into 5 options, and we made comparisons between the 5. In short, we considered that only 2 options are feasible. The first one is to extend the public inspection period from 2 weeks to 4 weeks, so that voters can have more time to inspect the provisional register and lodge claims or objections. The other option is to remain status quo. Now, on the face of it, these 2 options look similar in terms of their pros and cons, but in order to facilitate the public in inspecting the provisional register, we are more inclined to extend the claims and objections period from 2 to 4 weeks, and we will hear from members today and see if we will change our position, and if so, we're going to amend the relevant provisions and table them in the Council. The other suggestion has to do with false declaration in caption 541 to 555 541A and 541B to transfer these two types of offences to CAP 554 so that they can be enforced by a single enforcement agency, that is ICAC, together with other corruption, election and corruption offences. These offences will also become indictable offences at the same time with higher levels of penalty in order to achieve deterrence. We received some views and we consulted the police force and the ICAC in relation to their views on enforcement, and the views received are that at present these two enforcement agencies would like to see the status quo being maintained because of the division of labor.
We do have an existing mechanism for cooperation between the two law enforcement agencies. In short, they feel that we do not need to change the status quo. Regarding the penalty level, the paper states we have made reference to similar offenses, and we also made reference to previous rulings, and the judiciary does not call for a higher penalty level, so we don't need to increase the penalty level. But in order to enhance efficiency and add a deterrent effect, we do mention a legislative change. The 541A and 541B false declarations can be dealt summarily. In other words, there is a 6-month time limit. So we propose that these summary offenses can become indictable offenses, so they won't be limited to the 6-month time bar, and the police can feel that they can enhance efficiency and law enforcement. So we do not need to transfer these offenses to the ICAC, and we don't need to enhance the penalty level, but they can be made indictable offenses. So we feel that this strikes a balance between enhancing enforcement effectiveness and deterring effect, and we can also balance the public's willingness to register as voters. And if we can gather your support, we will make the relevant legislative amendments and propose them to the Legislative Council as soon as possible. Okay, before members ask questions, Ms. Emily Lau has asked the Secretariat for some old information regarding the Constitutional Affairs Panel follow-up information on the III election. These are just survey results. You recall that after the election there were a lot of complaints about vote rigging, and the government had conducted investigations and there was some information. This letter was dated on 12th of April. So we have had the Secretariat printed out for your reference. Okay, we have 5. Before we ask questions, does the Secretary have anything to add regarding these figures and the letter? Do you have anything to add regarding voter registration and complaints? After April, the ICAC investigation, we have a attachment, convictions. There were 45, and up till now this figure is 48. We do have other figures, some update, and Mr. Lee can supplement. Mr. Lee? Thank you. In the April letter, we mentioned the we had updated the progress on the measures, so we just had some preliminary information. The voter cycle has completed in 2013. We have more information. So in this year, we had investigated 140,000 voters, and we had issued 35,000 letters, investigation letters, and some 26,000 voters were deleted from the list, were omitted from the list. In the 26,000, these voters, poll card was returned and they did not provide further information, and they make up some 19,000. The second largest category are random samples, and we had made a random survey of 34,000 voters, and 3,000 were omitted from the voter list. Some 2,200 voters did not have complete address information, or their addresses did not seem to be residential addresses. So these 2,200 voters were omitted. So we can provide more detailed figures for your reference after the meeting. Okay, you can do so. Why can't they provide that now? I had asked for it last week. It was the same in March. Why can't they provide it now? They can just photocopy it. Do you have it on hand? I have some rough information. I just need to organize it. And we can submit it. We can submit it as soon as possible. We have 7 members who wish to speak: Lam Gin Fong, Emily Lau, Leung Mei Fun, Yau Si Wing, Lei Chok Yan, Yip Kok Him, Wong Bik Wan, Ho Chun Yan. So we have 8 speakers, 5 minutes each. Mr. Lam Gin Fong. The government wishes to enhance the voter registration. Well, I've heard a lot of concerns, especially we had cases of vote rigging or addresses being inappropriate and such. So I'd like to ask, because of career needs, people don't wish to make a long commute, so they will rent another living quarters, and they would spend more time in those quarters. So when they vote, when there is an election, they will use their original address to vote. So under these circumstances, in order to avoid voters making mistakes, could you clarify, is there any time requirement on the residential address, how many days you need to spend there? Or if they travel overseas, how does that affect their residential address? I would like to defer to Mr. Lee, because he is the authority to speak on this matter. According to current legislation, a member of the public who wishes to register as a voter needs to provide his major residential address. There is no time requirement regarding a residential address. In considering applications, we have to consider actual circumstances. And the legal opinion we get is that a person can have more than one major domicile, and we need to consider amongst the different domiciles what are the actual circumstances. If there are such scenarios, we need to ask the applicant to provide further information, or we might even need to seek further legal opinion. That's not clear, Chairman. Set aside people with different households, with multiple households. There's, let's say they have a bed, they have their daily necessities there. This is rather awkward. If the voter is not aware, and if you say you need to get a legal opinion, then I think that's very troublesome. If we have hundreds of inquiries, how will you deal with them? Could you provide some guideline? a simple voter, first of all, they need to know whether they've crossed the boundary. Well, I think the bottom line, first of all, any voter, if they have more than one domicile, they only still have one vote. They cannot register more than once. So we will enforce this. And if their address, it's not a false address, if they're not using a false address, then they won't be breaking the law. If they have leased or purchased different residences, as Mr. Lee said, it will depend on the actual case. If the voter has any questions, they are welcome to consult the voter registration office. Mr. Lee, if a person has 2 addresses, he needs to decide which is his major domicile. That has to be his sole or major domicile. And in our vetting process, if we are aware he has 2 addresses and he provides sufficient reasons for our consideration, and as long as we believe his declaration, then that's no problem. Ms. Emily Lau? The 2 amendments, we don't object. It's not very important, but we feel the government seems to be or wants to water down the public's concern about vote rigging. So allowing this April letter, we see the complaints. In paragraph 2, it says there were 9,900 voters, but in the end it says there were only 2,000 complaints submitted to the police. And in paragraph 3, it says, according to latest information, there were some 11,000 investigations. So we have the different sets of figures. So whether it is 9,000 or 11,000, this is quite a large number. And on the second page, we only have 52 people summoned to the courts. And if you refer to the attachment doesn't talk about court cases, it just talks about people involved. And just now Mr. Lee said in the ICAC there are 45 people convicted and an increase of 3 more to 48, but there are still 18 ongoing investigations. If you look at the ongoing police investigations, there are 390 investigations. So from 10,000 to a few dozen, well, even though we don't have evidence of negligence of work on the police and ICAC's part, but if you refer to paragraph 3 in this letter, 90% of cases don't have evidence of vote rigging. It's just old addresses. Well, have these address information been updated? Just now Mr. Lee also said, I don't have complete information. We are now discussing this issue that was handled last occasion, but you always say that you don't have enough information. Well, the Democratic Party feels that vote rigging is a serious issue. We understand the public is concerned. We don't want to turn people away from voting, but the public also feels that we shouldn't allow vote rigging. So how can you provide incomplete information to the legislature? The information in April was incomplete, and now we're in October. So you need to respond. You said nobody called for higher penalty levels, but the Democratic Party calls for a higher penalty because we want to give society the message that this is serious. If you are caught, you will be dealt with seriously. So please respond seriously.
Secretary. Now, Chairman, let's see if Mr. Lee has anything to add in relation to the past figures. In relation to figures, cases still on pending investigation. Basically, since April, some cases have been completed, and actually only one person involved is still outstanding. For ICAC, 2 persons. So I'd like to apologize for not being able to submit a written paper, but we have even a verbal report. We'll try to submit this information as soon as possible. Ms. Lau asked for the number of cases as well as the number of persons involved. We're going to provide this information as well. We also agree with Ms. Emily Lau that the issue of vote rigging is very serious, and that is why through the past few months we have launched a series of measures to enhance voter registration. I'd say quite a substantial check has been conducted on voter registration, and I think the register is more accurate than before. So in our paper, we mentioned the cases being investigated by the 2 enforcement agencies. Most of these cases had to do with old addresses not being updated by voters. Now that's one scenario. And in the consultation, we did say that for addresses not updated by voters, if this could also become an offense, well, we received many views on this issue, saying that it should not be made an offense. Now, I agree that vote rigging is serious. Therefore, during each voter registration campaign, we do emphasize the importance of observing this situation. And in the upcoming VR campaign, we're going to emphasize it as well. Mr. Lee, anything to supplement? Just to briefly supplement, Ms. Lau mentioned 9,940 voters in the second paragraph of the April letter. These were complaints received directly by the REO, and about the 3,000 and 8,000 respectively received by ICAC and the police. So these were complaints received by these 2 law enforcement agencies. We did refer some cases to them, but these are 2 sets of figures. Now, Secretary talks about the cases pending investigation. So what happens after the investigation? Are the cases brought to court or what? Now, the data is prepared in April, was prepared in April. So what happens to those persons? Secretary, anything to supplement? This is the information as at the 10th of April. What happens after that? Secretary. Now I have some up-to-date information given to me by the enforcement agencies. So may I compare this with the table annexed to the April letter? Perhaps I can submit this to the Secretariat and see if Ms. Lau would like to follow up on it. All right, let's look at the figures later. Dr. Priscilla Leung, Chairman. I think the purpose of the reform is to encourage voters to vote. Vote rigging should be dealt with seriously. According to the figures cited by Secretary, many voters were excluded from the register on random inspection. Voter registration is very important. I received many cases asking for assistance in relation to Hong Kong residents living on the mainland. Even inmates have the rights to vote, and their rights are very clear. However, for Hong Kong people working on the mainland or living for lengthy periods of time on the mainland, the situation is unclear. Sometimes, well, they choose not to return your mail, and as a result, their registration or their names have been struck out on the register. So the first question is whether you follow up on these people and tell them very clearly their rights to vote. Secondly, you talked about more indictable offences. But on the other hand, sometimes during an election, our opponent would use this kind of tactics, vexatious and frivolous litigation as a means of publicity. Sometimes even a wrong spelling would cause a case to be brought to the ICAC. We still need a very clear explanation on it. We have seen some very trivial complaints to lodge to the ICAC. So can this be followed up on as well, Secretary? Thank you, Chairman. Now about the voters' eligibility. Now the first suggestion in the paper is to extend the two-week public inspection period to 4 weeks so that voters can have ample time to inspect the provisional register or PR. And in the paper, we've also suggested that the REO will in due course implement changes. A new online checking system will be implemented by the REO. That is, apart from the 2 or 4 weeks inspection period, the online system can help the public check their VR status so as to assist any further inquiries. As for indictable offences, Dr. Priscilla Leung made a point on it. Now, during the last term, or the last legislative year, we dealt with some de minimis scenarios, and we have amended the law to implement the de minimis rule. That is, let's say if there is an error in the electoral expenditure, as long as the amount is fewer than a certain level, no law will be breached, etc., so as not to disincentivize candidates from taking part in elections. And if there are other suggestions that call for a review of the situation, please give us specific suggestions. And if we consider it necessary to follow up, these proposals will be incorporated in the upcoming amendment bill. Chairman, the Secretary hasn't answered my question. There are 2 types of Hong Kong people on the mainland. One type is frequent travelers. They cross the border on a daily basis. They can be excluded from the VR, and they don't have any address to answer your query, so their names would be struck out as well. So you should identify the places where these Hong Kong people live or frequent so that you can step up your publicity effort. You should try to retain them as well, instead of just going through the motion and exclude hundreds of thousands of voters from the register. They don't have time and they seek help from us. So if there are so many permanent residents living there, the administration should also do something more actively. In an upcoming voter registration campaign next year, we will consider the view of Dr. Priscilla Leung and see whether we can disseminate the message online or through the ETO. Next, Mr. Yu Si-wing. Thank you, Chairman. I support these 2 suggestions. Now, on paragraph 15 of the paper, it says the REO is actively exploring the feasibility to launch an online system whereby the public can check their VR status and personal particulars via the Internet. In the past, when we want to check our VR status, we would go to the district office but we could not photocopy or take away the information. That is for the purpose of protecting the identity of voters. So what will the administration do to protect the privacy of voters if checking can be done online? Now, the second point is about inquiry by telephone. Very often, no one picks up the call. I don't know what the situation is now. Some elderly people don't use the internet and they don't want to go to the district office. So I'd like to know something about the telephone inquiry arrangement, whether there is any performance pledge, etc. Now, on the enhancement measures, point E, about the options. Point E, I find this quite peculiar. Now, some buildings to be demolished or vacant premises will be checked, and the list will be identified, and the voter will be, letters will be issued to voters. But if the building no longer exists, so how can you issue letters to voters? Mr. Lee. Well, under the existing system, there are two ways for voters to check their VR status. The first method is to go in person to the district office, as mentioned by the member. But there is a constraint because such checks can only be conducted during office hours. The other method is to call the REO hotline. But again, there is a constraint. After we publish the register, we would enhance our service. It would work till 9 p.m., but there is still a constraint. Some residents might not be free until they knock off after 9. And we are trying to explore the feasibility of setting up an online system so that the public can check whenever they want whether he or she is a registered voter, and they can check the personal particulars. If there are errors, they can apply to the REO to update their personal particulars and rectify the errors as quickly as possible. We are exploring into this feasibility. If it's feasible, we hope to implement the new system by July or August next year. About online security. Yes, this is also our concern. We have been looking into this issue for a few years. We are also concerned whether the data uploaded online is safe enough, especially when it involves a large amount of data. But there is advanced technology to ensure safety of personal data. The technology is mature in this regard, and many banks are also adopting this security system. And what's the third question again? About demolition of buildings. On a regular basis, we work with the Buildings Department and the RVD. We get information from them to see what buildings have been demolished and what will be demolished. And then we will check against the register and see if any registration has been done with these addresses. We will, first of all, contact the voters by telephone. If the voters cannot be contacted by telephone, we will follow the statutory procedure. Which means that a registered post must be sent to the registered address to the voter first before we exclude his name on the register. So we will try to contact the voter by telephone first. If not, we will try to contact the voter by his residential address. And if no further particulars can be provided, we have no alternative but to strike out his name from the register. That means by using the internet, only that person's own personal particulars can be checked, because I understand that at the district office you can check the status of others. That's the major difference. Mr. Lee Chak-yan. Well, vote rigging is a major concern. And vote rigging definitely is not fair or impartial. So vote rigging is serious. But from the figures cited, it seems that the situation is not very serious, but it's very confusing. On this letter, first of all, it says that among the 9,940, 3,466 voters were not suspicious. As for the remaining 6,474, investigation would be initiated, and the police, together with the ICAC, investigated up to 11,000. And then the figure substantially reduced. So on the surface, it may look okay because there were just a few dozen. What about the remaining voters? Because there were 3,000 or so non-suspicious cases. What about those remaining 6,000 voters? They were suspicious, but no prosecution had been initiated.
If you want to if you want to convict them criminally, it's a very high threshold. You need to consider motive. Was it a very blatant vote rigging? And what about the other few thousand cases? They're just suspicious? You can't convict them? So that means they'll continue rigging votes. They'll do that next election because it's hard to convict. That's the conclusion I'll draw from these figures. And after police investigation, we have a lot of cases that cannot be established. So are they suspicious? And there's a number that we don't know. That is, out of the 10,000 reported cases, how many actually cast votes? So if they didn't vote, then they didn't rig a vote. But then you don't disclose how many cast their votes. Maybe half, 50% casted their votes. So those would be vote rigging. Because if you look at the result, you can say there was no vote rigging, there's just a few cases. But we have a large gray area. I think those are the suspicious cases. So the ones that were convicted were perhaps very blatant. But we now have a lot of cases that cannot be prosecuted. Are they suspicious, but you can't convict them? So how do we plug the loophole? Chairman, in our previous letter and the latest information, the majority of the cases were confirmed, the cases were not established after investigation. It's not just a matter of whether it was suspicious. The case could not be established after investigation. These cases that couldn't be established, the majority were because of the voters had not updated their address after moving house. So after providing information, we could confirm that the case was not established. So in the two law enforcement agencies, basically the ICAC deals with cases where votes were cast. In the police investigations, the votes were not cast. So convictions after investigations from the ICAC, there were 48 cases. In the police, there were 7 cases of convictions. And we have also included the number, the penalty in our information. Aside from the 48 convictions after investigations, if you for cases, there were only 4 cases where there was no conviction, where the case had been, went before the courts. So we believe the figures in the table reflect the work of the two law enforcement agencies, and the courts have also come to rulings, and these are very factual. Well, if that is the case, then the ICAC case involved voting. There were 8,000 cases. So you're telling us those complaints were insubstantial, but Hong Kong people are very reluctant to complain. So the 8,000 odd complaints, if they were not established, then if you're saying this were just old addresses that were used to vote, if that is the case, then the whole issue reflects that these 8,000 odd people, they weren't living in their addresses. That's why there was a complaint. So what's happening now? So these 8,000 odd, are they all just using old addresses? Let's see if Mr. Lee has anything to add, but I just want to add that the ICAC takes it very seriously. The ICAC had deployed a team to deal with these thousands of cases, and they had also made a press release and I believe after the investigations, their conclusions were made very thoroughly. Regarding the 8,000 cases that weren't established, let's hear from Mr. Lee. Well, I think the two law enforcement agencies, after investigations, if the cases weren't substantiated, we cannot provide further information. But I can add that regarding the police who feel that the cases weren't substantiated, we don't have the relevant information on hand. When we verify the figures, the voters did not register in the same year. Some had registered before 08. So the majority of cases might have forgot to update their address after moving house and gave people the wrong impression that they were using a false address. So perhaps that is the impression. This is police, not the ICAC. I just want to clarify that. Mr. Yip Kok Kim. Vote rigging is a serious offense. We cannot let them off the hook. We need to uphold fair and transparent elections. All members of Hong Kong public need request this. But it's now very hard to make complaints. There are a lot of unsubstantiated cases. I feel we have a lot of frivolous complaints. For example, the DAB in the Western District, we have a councillor the Democratic Party says that there were 100 odd rigged votes using false addresses, but these locations were being redeveloped, and the case went up to the courts, and ultimately they had to pay court costs. How could you call vote rigging? If there was an intention to enlarge the voter base, and but if a voter had moved a house, and forgot to update his address, can that be vote rigging? I don't think you can do that to mislead the public. You cannot blame an election loss and say it was due to vote rigging. Looking at the figures, we see that has the ICAC and police investigated the case? we have 8,000 odd cases that are not substantiated. The police say that there are 2,856 were not substantiated. Of course, there were convictions. The police have prosecuted and convicted some cases. Well, we cannot say that there is a big loophole in our voter system. I want to now refer to the provisional register. We feel that in the past, to check whether a voter status has been repealed, a lot of times it's voters cannot check. So when the voter wishes to vote, then they only find out that their voter status has changed. So we need to allow easy access, or voters need to find out whether their voting status has changed. After checking, can they update their status? Well, I would like to clarify that if a person finds that his status has been changed in the provisional register, can they remedy that? Can you respond? Mr. Lee? Mr. Yip-Gok-Kim, first question. We have already implemented that in the provisional register, where they listed by address. So if you want to, you can check by your last name or address. If we have disclosed the provisional register, according to the current legislation, they have about 14 days to make a claim, and we can help them check their status. There is a legal procedure where they have to check with the magistrate. So we now have a procedure. The document also mentions that on the last occasion, when we conducted public consultation, 14 days is not enough. Can that be extended? So this paper tries to deal with this. So we need to amend the other dates. So this is the problem we're trying to address. In the searching process, can you make it more convenient for voters to check their status? Can it be done by phone? Or do they have to go to the electoral office or the receiving officer to check? They don't have to go to the HAB. They can just make a phone call to the electoral office. But I understand there are business hours, so even when we disclose the provisional register, and even if we extend the working hours, there's still a limit. We might only work till 9 or 10 p.m. We cannot work around the clock. So we're now thinking of a new idea in the next voting cycle. Please do not interfere. You can queue. They can leave a voice message. We're thinking of a more convenient measure. We want to have a website so the voter or a member of the public, they can search the net and see whether they are a voter, and they can check their voter information. If there's any wrong information, they can amend that. Ms. Wong-Pik-Wan, I'd like the administration to explain who is a qualified voter. They need to have an address, the major domicile in Hong Kong. Just now, members mentioned that some voters might not be very clear about their status. They might be working on the mainland. They might be shuttling between Hong Kong and Hong Kong. So they have an address in Hong Kong, and sometimes they're not in Hong Kong. So how many days do they need to spend in Hong Kong to be regarded as having Hong Kong as a domicile? Could you explain? Some people who also work on the mainland, they stay almost permanently. They might only return to Hong Kong a few days or a few weeks a year. So if we don't have a workable definition, then it's hard to enforce the law, and they'll also be breaking an offense if they know that they are not registered, they're not qualified to vote. Some people who live on the mainland, they don't know whether they are qualified to vote in Hong Kong. We also have people retiring in Guangdong who are receiving old age allowance and other benefits.
So these elderly people are residing on the mainland on a long-term basis. Do they qualify as voters? If they don't, then is it against the law for them to vote in Hong Kong? And what about permanent residents holding the 3-star ID card? Are they qualified to come back to Hong Kong to vote? Just now, Secretary, in answering Dr. Priscilla Leung's question, said that he would liaise with the ETO in Beijing and other ETOs. Then will you also liaise with other ETOs in, say, Canada and the US, and asking them about the voter registration matters? Secretary? According to Section 48(1) of the Legislative Council Ordinance, those who qualify for registration as voters would need to meet the following 5 criteria. Age 18 or above. B, permanent resident of Hong Kong. C, at the time of registration, he usually resides in Hong Kong. And also the address, as stated in the application form, should be the main or the only residence in Hong Kong, and he must hold a Hong Kong ID card, and also he must not have been disqualified as from voting. And Dr. Helena Wong asked about voters not usually residing in Hong Kong. In the ordinance, it's quite clear that the residence or the residential address so stated in the application should be the main or the sole residence in Hong Kong. And by saying so, it means whilst in Hong Kong, that address should be the sole or the main residence. That voter might have other places of residence or other residential addresses in other countries, but in Hong Kong that should be the main or the sole residential address. And as explained in this council before, the scenario is a fact-sensitive one. We cannot give you a general rule on this. It depends on a case-by-case basis. However, I can give you some information. In Chapter 3.3 of the last elections guidelines, the EAC has the following advice. Now, for those usually resides in Hong Kong, apart from leaving Hong Kong for, say, for holiday or for furthering studies on a short-term basis, these eligible or qualified voters should meet the criteria. And the assessment would depend on the reasons for leaving Hong Kong, the length of absence, and whether the spouse is in Hong Kong, and whether he has any contact with anyone in Hong Kong. And these are factors for consideration. And in the schedule of the immigration ordinance, this can also serve as a reference. The Director of Immigration will consider the following factors. Number 1, whether he has a usual residence in Hong Kong. Number 2, whether the spouse or other dependent children are in Hong Kong. Number 3, whether he has sufficient income to support his family living in Hong Kong. And number 4, whether the person has paid tax duly in Hong Kong. These are the factors for the Director of Immigration's consideration. So we cannot generalize the situation, but one point is that it has to do with the degree of liaison with anyone in Hong Kong. One follow-up question. I don't know whether anyone understands what you are talking about. Can you give me a specific answer? I asked about the Guangdong scheme, about the elderly people who choose to age on the mainland, and for our welfare benefits, now they can be transferred for them to enjoy those benefits on the mainland. Now, for these elderly people who are not living in Hong Kong, are they still qualified to come back to vote? And what about the immigrants? I'm talking about the registered voters. Secretary, you read out the number of ordinances in such great details. So, and a member may not understand you very well. So please give us a very concise answer. Chairman, it tells us how complex this issue is. It's difficult to give you a concise answer, because on this issue, the Security Bureau, when dealing with these cases, will assess each case on their own merits. The first hurdle is not about usual residence. I think the first hurdle is about whether they have used a main or the sole address of residence to apply for registration. If this is not the main or the only residence in Hong Kong, then this first requirement isn't met. Then, even if other requirements are met, it may not help much. But let me clarify once again that for elderly people retiring on the mainland who are permanent residents, including many colleagues who have decided to retire in Guangdong, as long as they declare a residential address, then regardless of the number of days the person might be returning to Hong Kong, the address is used for his staying over, then it's highly likely that he will meet the requirement of that address being the main or the sole address in Hong Kong. But we cannot generalize all the cases. Mr. Albert Ho. Now, I'd like to talk about one case. The case was mentioned by Mr. Yip Kwok Him just now. That was in a DC election. I think there was a difference of just 20-odd votes. Now, I want to declare that the claimant was our party member, and in his petition, he listed some questionable votes. They used the address of a building which had been demolished. And for some voters, they used the address like a jockey club, off-betting center. And they had not been excluded. Now, when the case was taken to court, the court ruled that there was no legal requirement for them to change their residential address, and the fact that they had not updated their address did not affect their right to vote. So, Secretary, would this be reviewed after the decision handed down by the court? The voter may no longer be living in the same address, and should the law be reviewed, the result might just be affected by 10 or 20 votes. Now, this brings us to the point as stated in the paper, and that's the enhancement or improvement measures. Now, for example, for the housing department, they have household registration information. Many voters are not even household tenants in housing department estates, so these can be verified. And also commercial addresses, well, these should not be used as voter registration because the premises are not for residential purposes. Now there are 130,000 voters covered. And then you talked about the returned mail, returned poll cards. Now, but some poll cards might not have been returned. Say, for example, a Chinese restaurant, 100 people might use the same address to register their voter status, but not all poll cards will be returned. So one of the measures here is D, that is random inspection. How much has been done? Please tell us about your inspection work and how many were deleted. Secretary. Now maybe I'll ask Mr. Lee to supplement the second part of the question about demolished buildings, etc. Now, about the number of voters struck out from the register, there are quite many over the past 2 years because of our work. And about the case mentioned just now, I think Mr. Ho was talking about the High Court case, a decision made on the 2013 on the 1st of March about Zhang Hofai's case. Now, the Honorable Mr. Justice Lam said the following in his judgment: the law hasn't required the voter to inform or to report to the REO after the residential address has been changed. It is a civil obligation, not a legal obligation. As consequently, a voter will not lose his status as voter just because the address has been updated after the registration has been done. Therefore, for voters that have moved, if we try to contact them many times without any response, they will be excluded from the register. But of course, they can reapply for registration. As to whether there is a need to review the situation, we keep an open mind. If members think that apart from the series of improvement measures, more should be done, say on qualifications for voter registration, we can conduct such a review. However, what we have done is actually based on the common situation in Hong Kong. People move quite frequently in Hong Kong. For voters updating their residential address after registration in 2010 or 2011 or 2012, if I remember correctly, there were 200,000. I'm sorry, it should be 300,000 in 2011 and also over 300,000 in 2012. It was not an election year, and for the VR registration campaign, the updating of address amounted to 120,000. Now, some might have moved and forgotten to update their address, and if as a result they lose their eligibility as voters, we need to be very prudent. Of course, for vote rigging, we have also enhanced our measure in conducting inspections. Mr. Lee, after the 2011 DC election, we have taken a multi-pronged approach in checking and inspections, and it covered a wide scope. In the VR campaign, we issued 27,000 inquiry letters, covering some 144,000 voters. We issued 27 inquiry letters, and in the end, some 26,000 voters were struck out. Now, among the returned poll cards, we also have cases which we issued 21,000 letters to help voters update their personal particulars. We are referring to those living in housing estates under the Housing Department's management. Now, the PRH tenants also moved in and out, and we verify and cross-match the information with the Housing Department from time to time to ensure accuracy. Most of the tenants were required to update their personal particulars after they either moved in or moved out of the housing estates, and we assisted them in this regard. And we updated the information of 21,000 voters. In 2013, we selected randomly some 4,000 voters for checking.
We have to ensure the information is accurate for them to remain on the list. In the 34,000, we believe they could not provide accurate information, and 3,000 were omitted. So you see, we do omit quite a lot every year from the list. So we have omitted 210,000 voters in the Housing Department. If they're not a tenant there, what are you checking? Unless the information is wrong. Yes, they are not approved tenants, so they are living there, and you still allow them to register. Do you allow illegal tenants in the Housing Department to vote, to register? And if the building has been demolished, it's a construction site, then shouldn't those be deleted? Well, if it's a construction site, or if it's a commercial building or industrial building, after 2011, we had used visual inspection to see whether it's a residential address. If not, they will come under our investigation. The voter needs to provide further information. We cannot simply say that commercial addresses cannot be used residentially. Some voters might even use a theater as an address. We just need sufficient evidence that that is their domicile. And let's say in the Housing Department, when we check information with them, if we know somebody has located into a Housing Department, but they are not using a Housing Department address, that might be because they have been allocated public housing, but they have not been able to update their information. So we will issue them a letter telling them we will update the latest information and we'll use the Housing Department information. This is authorized by the law. So we will notify the voters that we will update their information according to the information provided by Housing Department. Well, sometimes they will say, my family members have moved into public housing, but I have not. And we will ask them to provide further information. Well, you haven't talked about illegal tenants. Some people don't have, are not registered in public housing, but they use a public housing estate address. So will you would you disqualify them? Well, we have conducted a comprehensive investigation. We will vet their information, whether they are tenants in public housing, and if they are not qualified, if the information is incorrect, we will investigate. For example, they use a public housing address, then, but if they are not on the public housing tenant list, we will follow up with investigations. Then we'll ask them to provide relevant evidence Of course, you need to separate. When we check information with Housing Department, it's for voter registration. We're not helping them to do anything else. So we're only concerned whether the person is really living in the application address. Mr. LegCo. The biggest vote rigging mechanism, I think that should be reformed first. From the Arts Development Council to our colleagues here, they all enter on a. Are we talking about vote rigging? I'm interested in the functional constituency. That's the biggest loophole. It can be an association and an individual. Have you considered that? I'm not interested in minor details. You can enforce the law, but you just won't. You can check with the construction sites, housing department, and even emergency alerts. If they change the address, you can arrange for an emergency alert. It's very cheap. When they move the house, they can notify the election office. You can charge them $10. It's very easy. I'm interested in the functional constituency vote rigging. You call for step-by-step progress. We won't have direct elections. We'll only have them by 2020. Between 2016 and 2020, there's only 4 years. From now till 2016, we only have 3 years. So, Mr. Tam, the reform in functional constituencies, how will you monitor the people in those associations? And very few voters have a seat. It's not in proportion. If you can't reform by 2016, what can you do in 2020? How do you know that there can't be direct elections for the CE in 2017? So how will you know that it can't be done by 2017? Mr. LegCo, your question is beyond our discussion. We're talking about improving the voter registration system. Please do not continue discourse with him. You're saying vote rigging is a serious offense. It's my speaking time. Could you tell him to stop? Is it my time or his time? Chairman, he's cussing again. You can look at the clock. Mr. LegCo is using foul language. Mr. LegCo, I told you you're not sticking to our agenda, and I stopped you from continuing your question, and I Let me answer the first half. The election office, if they are suspicious of certain circumstances, they will follow up, whether it's a functional constituency or geographic constituencies. They can follow up according to the law. We will not relax any cases of vote rigging. We will also meet with Mr. LegCo to exchange views. Ms. Zhang Laiwan. Chairman, I think the public want to exercise their civil rights. They want to register as voters. In the 2013 March ruling, people lived there in the building, but they relocated, and some people forgot to update their address, and they were criticized by Mr. LegCo of vote rigging. And I also understand that in Meifu Estate, there have been more than 10 surnames registered to one household. So they want to exercise their civil rights, register as voters, but they ultimately didn't vote. So the public feel it's very cumbersome. And if you want to criminalize it, the public dare not register. They almost dare not register. And you now have a 6-month time frame, and now you want to remove the time barrier. So you can conduct random investigations and whether you have updated the address. They can be prosecuted and imprisoned for 6 months. So people are given this wrong impression. So could you consider this? I think we also shouldn't make things overly complex. People should have a permanent address in Hong Kong or permanent domicile. Some people find it cumbersome. They might have used their parents' address as a permanent domicile address, and rents fluctuate a lot, so people move around a lot. So how can they update their address? So our policy should encourage people to exercise their civil rights, and they should not be penalized. It sounds like a pain now. Why are affairs so complex? Just one person, one address. Some political parties imagine there's vote rigging. If you have evidence, you could submit it to the police or ICAC and investigate. If there is vote rigging, then follow up. We had an election last year and the previous year, and more than 10,000 people were investigated. Do we have? That's a waste of police resources. So you should not treat people as being dishonest. It should be as simple as possible. Like the young people, they don't want to register as voters. They're always changing address. They change every 6 months. So, Secretary, I think the simpler the better, and the time bar, I think, is not fair to the public. We need. You are referring to summary offense being an indictable offense. Ms. Zhang Laiwan has given me the opportunity to meet with voters, so I need to clarify. We're talking about fraudulent representation, not a lack of updating address. The latter is just a civic duty. They need to register their new address after moving. So you shouldn't misunderstand. Otherwise, they should not misunderstand that if they don't update the address after a certain period of time, they will be it is a criminal offense. And regarding the time bar of prosecution, the time bar under a summary offense, when they make an application till they need to be appear in front of a court, there's just 6 months time. In reality, we find that is not desirable. So in the paper we mentioned that we wish to change this to be an indictable offense and extend the 6-month time bar.
In relation to the severity of the offence and the level of penalty, these have remained unchanged. But in terms of the deterrence and the effectiveness of police enforcement, we believe that this can be improved. Hence the improvement proposal in the paper. We want to make sure that the particulars submitted to the REO should be accurate, should be true and correct. I don't see a problem here. Dr. Ann Chang. Thank you, Chairman. Mr. Tam, I am talking about the false declaration or false statement that you just referred to. Let me quote another example. I lived in North Territories East, New Territories East, and then I want to live in West. I want to stay. Spend more time in West Kowloon, and I also have a flat there. And then somebody warned me. I was asked which area or which district I should register as. And then I was warned that I should count the number of days I spent in each district. And then I wanted to be a good citizen, but in the end I thought that it would be too cumbersome. So there are many people like myself having 2 flats in Hong Kong or 2 homes in Hong Kong, and I really lost count of the number of days I stay in each home. So what is the definition of the usual residence as stated in the Basic Law? Perhaps I'll ask Mr. Lee to supplement. Actually, he explained earlier in this meeting that where there are more than one genuine residences in Hong Kong, the legal requirement is that you should report them, declare the main or the only residence in Hong Kong. Mr. Lee, yes, please do explain to me again. Now, the existing ordinance requires the voter to submit an address which is the main or the sole residential address in Hong Kong. There is no clear definition as such in the law. We need to look at each case on its own merits, and it's also fact sensitive. Now, a citizen may have 2 residences, and whether both will classify or qualify as the main residence, I think the citizen will need to provide information. Say if the resident stays longer in one place, then that would become the main residence. And another relevant factor is whether the citizen is staying together with his family there. It's impossible to count the number of days only to judge this matter under the existing law. Well, Chairman, that means there is no answer. There is no way to judge. No, he's given an answer. So please explain to me whether this is the main residence. Well, there are a number of factors to consider. So what are the factors? Oh, he already mentioned those factors. How many days you live there? How can I remember how many days I spent there? That's one of the factors. And there may be other factors so that you can prove whether this is the main residence. Even if you ask a lawyer, I think the explanation will just be the same. So there is no answer. Well, it's not that he didn't answer. Maybe you didn't understand. Chairman, is it my turn yet? Yes, Mr. Michael Tien. New People's Party support the offences under 541A and 541B in relation to the false declaration offences. They should be changed from summary offences to indictable offences. And the lifting of the 6-month bar, in our view, will help initiate the prosecution procedure any time beyond the 6-month limit, and greater deterrence can be achieved. And the administration already explained very clearly just now that it's very flexible. As long as it is not a false reporting, as long as you once lived there, or you're currently living there, or you are about to live there, this can be a main residence. It might be a seasonal. You might reside in one place based on the season. So I think this flexibility should not cause people's concern. Now, I have one question. The New People's Party thinks that if you remove the 6-month time bar, there is a greater chance for someone to be prosecuted under CAP 541A and 554. In the past, when the ICAC was in charge of the CAP 554, very seldom would ICAC initiate prosecution within just 6 months. And if this 6-month time bar is removed, then very likely the person might be contravening both ordinances. And if the offence under 541 is transferred, whether it should really be transferred to CAP 554, it's either carried out by one enforcement agency or the other. Please explain to us, Secretary. Thank you, Chairman. Thank you, Mr. Michael Tien, for supporting our proposal in transferring this or changing this into indictable offences. For transferred offences to be followed up by another enforcement agency. Now, the police is looking at false declaration without the voting being carried out, whereas the ICAC is looking at the other, looking at the false declaration with voting activities. As explained in the paper, there is a difference in terms of penalty level. It will change from 6 months to up to 7 years. We think that if the time bar of 6 months is lifted, it will achieve greater deterrence already to prevent vote rigging. And as mentioned by Dr. N. Chang, some people might be over-worried, and we can address these issues by striking the right balance. Now, if a person has committed a number of offences under various ordinances, the prosecution authority can prosecute those several offences that can take place afterwards. Mr. Michael Tien. So your major concern is not the case that one enforcement agency will be burdened by a heavy workload. Your concern is that for false declaration, even if no voting takes place, the voter should not receive the greater punishment, and therefore 2 separate enforcement agencies should be deployed to enforce the 2 separate ordinances. Mr. Tony Chair. Now, on vote rigging and false statement, now for functional constituencies or professional sectors like myself, I would like to reassure Mr. Leung Kwok Hong that it's not very easy to have vote rigging taking place in our sector, because you need to have professional status and examinations followed by accreditation by institutes before a certificate can be issued. So in relation to vote rigging or false declaration, in my functional constituency, I can say that the chance is 0. This is the first point. I want to clarify this point so that one doesn't think that it's easy to become either an architect or an engineer or a surveyor. Now, for functional constituencies, many professionals might qualify to vote as electors, but whether they will register themselves, that's another matter. For those who qualify as electors, they should register themselves as voters to exercise their civic obligation. So maybe the trade associations or the institutes can play a role in encouraging more electors to carry out voter registration. Now, on the enhancement measures or the improvement measures of voter registration system, they have been regularized since 2011. And I have a question. One practice is random check. I wonder if this will be done every year. Chairman, as mentioned just now, different figures were quoted for different years. I'd like to know on what basis is the number of random checks carried out. As Secretary, I will take the first part of the question and I'll defer the second part to Mr. Lee. In our next VR campaign, we're going to incorporate the suggestions of Mr. Chair. Mr. Lee will answer the following, the remaining parts of the question. On the registration of electors for functional constituencies, very often we find that we need to rely on the relevant professional bodies to give us information. Now, if a member of that FC has registered himself as a voter for GC but not for FC yet, then according to the law, we will issue a letter to remind him to register himself as an FC elector. And if that person has not even registered as a GC voter, we will issue a reminder notice to him, and we will continue to liaise with the professional bodies and step up our publicity effort. And some institutes might have newsletters or websites, and we will place advertisements on these websites and newsletters as far as publicity is concerned. Now, random checks, since 2011, yes, they have been regularized. And it depends on whether it's an election year or non-election year. As far as the number of random checks is concerned, there'll be more during an election year and less during a non-election year. If there is no basis to suspect or query the residential address of registered voters, it's not reasonable to conduct checks. However, to address public concerns, since 2011, we have launched a random checking exercise. And in the whole exercise, random checks do not constitute a large percentage. We take a risk management approach. For those now we look at the addresses and see if they are residential addresses. If they're not, then we'll do more in this regard. Mr. KK Fong. Para 24 on enforcement. Now, there was incident with Kings Park in our council. Now for that constituency, we need to hold a by-election. But before the by-election, we raised a query with the district office and the Home Affairs office, Home Affairs Department, but they just watered down our question. The candidate garnered the support of voters, and we tried to lodge a complaint, and the complaints were turned down by the two departments, and that's why we went to court. And it was a time-wasting exercise. It took over 18 months with a lot of money wasted. In para 24/25, it said that there is nothing problematic with enforcement, but I find this very problematic. The other suggestion is this. For territory-wide constituency, can we waive the voter registration requirement? For example, for the CE election, the whole of Hong Kong will come as one constituency.
The first point, Mr. Lee can clarify that. He didn't hear my question. The situation you're referring to is serious, so I hope the fact that you have objective facts. Could you let the Secretary respond before you the election? Mr. Fung is referring to two situations. The Super District Council, we have a proportion system, and second, if they pass the three elections and in the 27 CE election, one person, one vote election, then the major domicile requirement will be lesser. I understand his view. Currently, we are doing some internal research. For example, some other jurisdictions where they have elections and whether there's a district differentiation. We're doing research, and we will report to you when we have further findings. This is something that we need to look into. Mr. Lee, I'd like to add in 541A and Cap 541B, the law enforcement agency is the police department. So if a member of the public, if they discover someone has contravened 541A and 541B, they can go to the police. And second, they could go to the election office to make a report. So when we receive these complaints, we will refer that to the registration and electoral office, and these will be investigated by the police. I won't comment on Mr. Fung's case, but if you say that the registration and electoral office has received these complaints, we will hand it back to the Electoral Commission, and the Electoral Commission will hand it back to the police, because we don't have any powers of investigation, because it involves criminal prosecution. I just want to follow up. A lot of people might be very aware of which agency will handle what. For example, the electoral office would refer to some other body, but I hope your response can be followed through. In the second round, we have Ms. Emily Lau. Thank you, Chairman. You've heard so many problems. I feel the Secretary needs to handle the different questions that were raised so the public can check whether they are voters or whether they have broken the law. And I would also like to see the penalty increased to give the society a clear message that we do not tolerate vote rigging and they need to be dealt with severely. So if there is vote rigging, it's not just one person. If they are vote rigging, there is a reason, a motive behind that. So have you investigated what groups are involved? It's not a frivolous act or an arbitrary act on an individual basis. The new arrangement of when the provisional register is disclosed, they can examine each residential unit. In the past they couldn't. But now they can identify 18th floor Unit C, and you can see 12 people registered, 8 people registered there. Can that be done? After consulting the public a year ago, so aside from previous listing format, we have implemented the new format. It can make it convenient to see whether more than a dozen last names are registered to a unit. This can now be made much more transparent. Regarding the law enforcement agency, aside from looking at complaints, will they look at whether there is any organization or group of people behind these activities? Well, I think the police and ICAC will follow through very carefully. They will see whether other laws are breached, and they will look into this very seriously. And most importantly, in our investigation measures, we want the provisional register to be clear, and people can check their status very clearly. And third, we welcome any reports. I think that will have a deterrent effect, and repealing the time bar in effect will enhance the deterrent effect. What about penalty level? Will that be increased? As the paper says, if we combine the two under the same legislation, the most serious penalty will be a prison sentence from 6 months to 7 years. And by removing the time bar, will enhance the deterrent effect. And when we implement that, if we need to increase the penalties, of course, we will keep an open mind towards that. In the dozens of cases convicted, in the information we provided, we see penalties. The maximum penalties are similar to the Electoral Affairs Ordinance. So if you look at the severity of the cases, there's no need to substantially increase the prison sentence. But in the future, if necessary, we can review that. So we had 13 legislators speak and raise questions on this item. We would like to encourage more people to register as voters, and they should not be scared or feel that it's too cumbersome. And I'm aware that the courts, in their rulings, the penalties are not high because the facts might not be that serious, or it might not be intentional, and therefore the ruling did not include the maximum penalty. Now, regarding the summary offense being an indictable offense, the summary offense deals with lighter crimes, and removing the time bar is not that very frequent. So the government says that by removing a time bar, it can have a deterrent effect. So we'll wait and see. So we now move on to the next agenda item. Agenda item number 4, the proposed creation of one supernumerary post of principal executive officer in the Registration and Electoral Office, CB 266/13/1405, provided by the government. We have Miss Ann Teng, Principal Assistant Secretary for Constitutional and Mainland Affairs. The electoral office had just completed the recent election cycle, and we're preparing for the next cycle. The next cycle will run from 2015 to 2017. There will be a few elections, including District Council, Legislative Council, and then the CE election. We foresee that these will run from November 2015 to 2017, and we've assessed the manpower needs, and we foresee that the workload will be heavy, so we suggest that the Registration and Electoral Office create a supernumerary post of Principal Executive Officer. This Principal Executive Officer, his duties will be introduced later. I'd like to add that after legislators provide their input, we hope that by the end of the year to submit our application for this post in the Establishment Committee and approval from the Finance Committee. Mr. Lee, anything to add? Ms. Tang had talked us through the document. I'd like to add that according to past arrangements, the REO will create these posts, and it will add non-civil service posts to ensure elections will run smoothly. We had created a supernumerary post before, and to deal with the 2012, we had also had to do work on monitoring the process. We foresee that the workload and complexity will not be any less than the previous cycle. So between November 2015 and March 2017, in these 17 months, there will be 4 large elections, and the Legislative Council, the CE election, and the nomination election have to be conducted sequentially in 9 months. So the election office workload will be very heavy. So we have a very impending and urgent need to create a stable workforce. Similar to the previous cycle, we will have a task force to handle the actual activities. So we need a person with the relevant experience. So we propose to create a supernumerary post with a time limit. The duties of this post can be found in the annex. So during the nomination up to the election date, the person will be responsible for all the affairs, and the principal electoral officer is the only principal executive officer aside from the administrative duties. He also needs to coordinate the different activities during the period, and he also needs to monitor the work process. The workload is heavy, and considering the 2008 and 2011 election cycle experience, the principal executive officer cannot set aside, though the chief executive officer cannot handle the workload. So in light of the previous experience, we feel that in the next cycle we need to create the supernumerary post to ensure that all the work can be handled by a relevant officer.
So we're proposing that this post can be created starting from the 1st of April until the for 45 months until 2017, and this principal executive officer can have sufficient time to finish the follow-up work after the 2017 chief executive election. For example, the application for reimbursement reimbursement of expenses, and also to draw on the experience when planning for the next round of elections. A database can be built. So much for my presentation. I'm happy to take questions from members. Now, we're scheduled to end at 4:30. So 2 members would like to ask questions, so I will extend the meeting appropriately to 4:45. Mr. Chen Chi-chun. Thank you, Chairman. I very much agree that in the coming years we're going to have some major elections. Some may be one may be unprecedented, one person, one vote CE election, let alone the de facto referendum. So I'm very concerned about the manpower at the REO. There should be sufficient manpower at REO to prevent any major errors and omissions. Now, several points about this administration's paper. One of the purposes of creating this post is to help the 2016 nominating committee election. And according to the footnote, it is assumed that a nominating committee will be formed by an election. Now, apart from this assumption, which is the committee will be formed by an election, what are the other consumptions? How about appointment, or the all the legislative and LegCo members becoming ex-officio members, or by drawing lots, for example? And also an assumption that 3 million people in Hong Kong will automatically become a member of the nominating committee. Is that one of your consumptions? My question is that for with different assumptions, there will be different arrangements for the REO in terms of the expenditure and the manpower deployment. And have you considered, in the event that the Legislative Council vetoes your proposal, then will it be a waste of public money? Ms. Tang. Thank you, Mr. Chen, for your comment. Now, first of all, the chief executive already announced that a committee will be formed under the lead of the chief secretary for administration on constitutional reform, so that the consultation paper can be released towards the end of the year. So very soon, I'm sure Mr. Chan will also raise the same points. As we understand that the election cycle will start in 2015, and we are looking at manpower deployment at the REO, we'd like to have a preliminary estimate of the manpower resources so that work can start smoothly at in the next election cycle. As to whether the electoral method will cause any difference in manpower deployment. I believe the REO have considered various proposals and analyses under different scenarios. And our proposal is to follow the last election cycle's practice, that is to create a time-limited supernumerary post to help the chief electoral officer in dealing with the 4 elections. Now, my simple question is, what if the 3 million people in Hong Kong automatically becomes a member of the nominating committee? Is that one of the consumptions? Now, Mr. Tang, like I said just now, any consultation on the electoral methods, I think the Chief Executive already announced the relevant arrangements. I won't supplement any further details in this paper. Next, Ms. Emily Lau. Thank you, Chairman. Chairman, I don't have much view on this, on the creation of this post. I can see that the REO's workload will become very heavy very soon. And we must be fair in saying that Mr. Lee is very hardworking, and himself and his colleague would respond very quickly to our inquiries. Electoral matters are very complex. Very often clarification is needed. Well, we talk about a number of elections. I hope that we can have one person, one vote for all these elections. Save and accept this nominating committee election. I hope it can be as democratic as possible. Of course, if we have as many, there should be as many voters as possible. So, Mr. Lee, I hope that preparation work can be done properly for these few major elections. Now, on polling stations. Chairman, we have discussed this issue time and again. Very often we need to beg for venues to be used as polling stations. Those venues should be convenient for voters to go to vote. And I hope that you can give this a careful thought. Please don't change the venue of polling stations all the time, because the voters might not know where to go, and there should also be barrier-free access. Now, on the counting of votes, in the past, views were expressed on the venue of counting vote counting station. It was near the airport. So I hope that you would start preparation as soon as possible so as to facilitate citizens and voters. Also, on the point of complaints, I think Mr. Lee can take this question. Very often on the day of election or even before that, you would receive many complaints, and some say that very often you would disregard the complaints and they need to approach the police instead. But you should help them so that for the aggrieved citizens, when they lodge a complaint with you, you could take action swiftly. So I hope the preparation and the arrangements could be implemented smoothly so that people won't feel that you were passing the buck. Mr. Lee, anything to respond? Chairman, on polling stations, I think this problem will continue to exist. It's not an easy task to set up polling stations in Hong Kong, but Ms. Lau, I can reassure you, because we have limited choices, the polling stations will not actually change venues all the time. Very often those venues might already been occupied by other activities, and we need to consider the operational needs of those organizations. I can be frank with Ms. Emily Lau. In fact, we try to use the same venues as polling stations. It's only advantageous for our operation because voters might ring us and ask where the polling station is. If possible, we try to stick to the same venues. For barrier-free access, during the last election, we managed to get 93% of them barrier-free, and we hope to achieve more this time. Many polling stations are in older buildings, and as members understand, barrier-free access or barrier-free facilities in older buildings might not be possible. Sometimes we can prepare ramps to replace steps, but too many ramps might be dangerous as well. We try to do our best, and we try to make sure that 90% of the stations are barrier-free. On the central vote counting station, last time it was done in Asia World Expo, and there was a concern whether the location was too remote, whether it would be inconvenient for people to travel there. But judging from the past experience, as long as there was sufficient publicity on and relevant information given to the candidates and their aides, it wouldn't be too difficult. But of course, should a suitable location be identified in the urban area, we would very much hope that this can be done in the urban areas. But we didn't have much choice. There were only 2 to 3 exhibition venues. We'll continue to find a suitable venue. On complaints, every year we understand that we must do more. Sometimes there is a misunderstanding that the REO is not handling the complaints properly. However, most of the time these complaints involve offences which can only be investigated by the ICAC or the police, and some must be followed up on by the Electoral Affairs Commission. And perhaps we didn't explain ourselves clearly. So we will remind our staff and our officers to explain very clearly to which authorities the complaints will be referred, so that the aggrieved subject can have reasonable expectation on the authorities to follow up on their complaints. Now, another point, you said that some venues have been booked in advance and therefore could not be used as stations. Now, this is 2013. I don't know when you can fix a date for the date of elections. I don't know whether you can book the venues with them 2 years in advance, or whether you could only make such a booking at a very late stage so that people would turn you down. Well, we would discuss with the administration on the actual dates of election, because only when the decision is made, only when the gazettal process has been gone through, can we liaise with the venues on. So we have to wait for the date to be gazetted. In fact, for the LegCo election in 2012, that's how we worked with the REO. We tried to set down the election day first, that is the 9th of September, and once the date was set down, the staff can then confirm the venue for polling stations. And this, we will continue to use the same practice in confirming the dates and the venues. Apart from the polling stations, for the central vote counting station, we also need to book the venue in advance, and we'll try to be as careful as possible in the future. Mr. Yip Kwok Him. Thank you, Chairman. This meeting will end at 4:45. So a short note on the paper. We support the creation of the supernumerary post, because 2015 to 2017 will be a very busy period for elections. Okay, this paper can be submitted to ESC. For the questions raised by Ms. Emily Lau, I think there are other occasions we can discuss it later. If there are no items on the AOB, then the meeting is adjourned.